Hollywood gave the cowboy a gun, a horse, and the freedom of the open range. What it didn't show you was what happened when he stepped out of line. The punishments cowboys actually faced were brutal, arbitrary, and, in almost every case, completely legal. There was no union to call, no labor board, no lawyer who would take a cowboy's case against a rancher who owned half the county. You showed up, you worked, and if someone decided you needed to be punished, the trail boss, the rancher, the marshal, or the mob, you faced it. These are 20 brutal punishments cowboys actually faced that were totally legal. Number 20, the drag position. Every cattle drive had a hierarchy. The experienced men rode point at the front, the decent hands rode flank along the sides, and the man who had done something wrong rode drag. Drag was the position directly behind 3,000 cattle moving through open country. For 10 to 15 miles a day, in every kind of weather, the drag rider ate what the herd left behind. Dust so thick it turned day into dusk. Manure kicked up by thousands of hooves. The smell and the filth so constant that experienced cowboys said you could identify a drag rider from 50 yards away. It was assigned deliberately. New men got it automatically. Men who had violated trail discipline got it as punishment. Men who complained got it for longer. There was no appeal. The trail boss decided. His word on a cattle drive was absolute, legally and practically. What he said happened, happened. This was not informal hazing. This was the formal disciplinary structure of the frontier cattle industry. Number 19, blacklisting. A cowboy who was fired didn't just lose his job. In the cattle industry of the 1880s, he could lose his career. Ranchers across the northern plains shared blacklists, physical documents that circulated among employers in a region. A name on the list meant fired for cause, drinking on duty, disobedience, suspected theft, or simply annoying the boss at the wrong moment. The Wyoming Stock Growers Association maintained one of the most systematic blacklists in the West. A cowboy whose name appeared could not find work at any association ranch, and the association controlled most of the ranching territory in Wyoming. There was no process to challenge the listing, no right to know why your name appeared, no mechanism to have it removed. A man could find himself unemployable across an entire territory because a single employer chose to put him on a list, correctly or not. Number 18, legal flogging. In 1807, Tennessee law provided that a horse thief should receive, on his or her bare back, up to 39 lashes. That statute was not unusual. Public flogging was a legal sentence in multiple frontier states and territories well into the 1880s. A cowboy convicted of theft or assault could be sentenced to be publicly whipped at the courthouse steps, in the town square, wherever the local authority chose to make the point most visibly. The lash was not a symbolic gesture. 39 strokes from a leather strap left permanent scarring. The number 39 was not chosen randomly. It was one below the 40 strokes believed to be fatal. In 1828, the Virginia Supreme Court formally held that whipping a defendant was not cruel or unusual punishment. It remained a legal sentencing option on the frontier long after that ruling. Number 17, branding as criminal punishment. The brand on a steer identified its owner. The brand on a man identified his crime. In several frontier states, convicted thieves, including cattle thieves and horse thieves, could be legally sentenced to be branded. The letter T burned into the hand or cheek. H and F for horse fraud. Letters chosen so that anyone who saw the man for the rest of his life would know what he had done. The branding iron was the same tool ranchers used on their herds, heated in the same fire, applied by the same hand. The pain was identical. The permanence was identical. The difference was that the steer didn't have to live with knowing what the mark meant. Courts handed down branding sentences without controversy. It appeared in the same paragraph as fines and imprisonment. Just another tool available to a frontier judge who needed to make a point. Number 16. Ear cropping. Public humiliation records from the 1800s confirm that ear cropping, the legal removal of part or all of an ear as criminal punishment, extended into the frontier era in parts of the United States. A convicted offender would be sentenced to have a portion of one or both ears cut away, typically in public, as part of their sentence. The wound was not treated in any clinical sense. The mark was permanent and immediately visible to anyone who saw the man's face. Like branding, this was not extralegal violence. It was a sentence delivered by a judge and carried out by an official. The frontier was not squeamish about what punishment looked like. If the purpose was deterrence, the logic went, then the mark needed to be visible. It needed to follow the man. And it did, for the rest of his life. Number 15. The public pillory. Being placed in the stocks was not a relic of the colonial era that disappeared before the frontier period began. It persisted. A convicted man was locked into a wooden frame, head and hands secured, and placed in public for hours or days. The purpose was not containment. It was humiliation. The public was expected to participate. Rotten food, mud, stones, in documented cases, animal waste. This was entertainment and civic duty simultaneously. People were killed in the pillory. Stones are not precision instruments. A man who had wronged the wrong person, or simply had bad luck about who showed up, could take enough impact to die. The death would be recorded as a punishment complication. Number 14. Tar and feathering. The image is almost comic. A man covered in tar and feathers stumbling out of town. The reality was not comic. The tar used in frontier-era tarring and feathering was pine tar, heated to a temperature that caused immediate, serious burns on contact with skin. It did not peel away cleanly. Removing it meant removing layers of skin with it. The feathers were secondary. They were humiliation. The tar was the weapon. While tarring and feathering was technically extralegal, carried out by mobs rather than courts, frontier communities treated it as an accepted consequence for specific behaviors. Tax collectors, land agents, men who violated community codes. The mob that carried it out faced essentially no legal consequences. It was legal in the only way that mattered on the frontier. Nobody stopped it, and nobody was punished for doing it. Number 13. Lynching as frontier justice. Montana holds the record for the bloodiest vigilante period in American history. Between 1863 and 1865, vigilante committees executed hundreds of men, suspected horse thieves, accused robbers, men who had annoyed the wrong people, without trial, without charge, without any formal legal process. No arrest, no arraignment, no verdict, just a rope and a tree. The courts, the sheriffs, the territorial governments looked the other way. Prosecution of vigilante groups was vanishingly rare. The extra-legal hanging was tolerated because it kept order of a kind. A cowboy falsely accused, or accused by a man with a grudge, had no protection. The mob decided. The mob acted. That was the end of it. Number 12. Forced banishment under threat of death. A cowboy who violated community standards, or simply made enemies of the right people, could be subjected to what frontier law called banishment. The process was informal, but the threat was absolute. The sheriff or a vigilante committee would inform a man that he had a set amount of time, sometimes 24 hours, sometimes less, to leave the county. If he was still present when that time expired, the consequences were understood. He left with whatever he could carry: his land, his equipment, his animals. Whatever he couldn't take was simply gone. There was no legal challenge because, in most frontier jurisdictions, no legal structure prohibited it. Number 11. Compulsory witness duty at public executions. This one tends to shock people when they first encounter it. Sheriffs on the American frontier had the legal authority to compel attendance at public executions. Citizens could be required to appear as official witnesses to a hanging. Failure to appear when summoned could result in fines or short-term detention. The purpose was twofold. Executions required legal witnesses to certify that the sentence had been carried out. And beyond the legal requirement, public executions served as civic education. The government wanted people to see. It wanted the lesson to land. For a cowboy summoned from his bunkhouse on the morning of a scheduled hanging, attendance was not optional. He stood in the crowd. He watched. He went back to work. If the drop was miscalculated, if the condemned man strangled slowly instead of dying quickly, he watched that too. Number 10. The ball and chain. In the territorial prisons of the American West, the ball and chain was not a figure of speech. It was a 12-pound iron ball attached by a chain to an ankle shackle. A prisoner sentenced to wear it did not remove it to sleep, did not remove it to work, did not remove it for any reason until the sentence permitted. At the Yuma Territorial Prison in Arizona, the ball and chain was the standard punishment for escape attempts and serious rule violations. Prisoners wore it while performing forced labor in summer temperatures that regularly exceeded 110 degrees Fahrenheit. The weight of the ball changed how a man walked. After weeks, it changed the structure of the ankle joint itself. Prisoners who served time with the ball and chain in Yuma typically walked differently for the rest of their lives. Those who survived to walk at all. If this version of history is hitting different, subscribe and hit the bell. The final 10 items are where it gets darker. Number 9. The Snake Den at Yuma Prison. The Yuma Territorial Prison was built on a bluff above the Colorado River in the middle of the Arizona desert. It was called the Hellhole of the West. The facility's punishment cell was a room cut into the hillside, measuring approximately 10 by 15 feet. No bed, no furniture. A tiny ventilation shaft in the roof that provided the only light. One meal of stale bread and water per day. No contact with other inmates. It was called the Snake Den because snakes and scorpions entered through the ventilation shaft. Whether they got in on their own or were dropped in by guards, the historical record is not definitive on this point. The longest documented stay in the Snake Den was 120 days. The man who served it never went back in. A cowboy who ended up in Yuma for a cattle-related offense, rustling, brand fraud, assault, faced this cell for violations as minor as failing to shave once a week or not making his bed to the guard's satisfaction. Number 8. Debt bondage at the company store. On isolated ranches far from any town, cowboys often had no access to goods except through the rancher who employed them. The rancher sold food, clothing, and supplies on credit, deducted from monthly wages. The prices were set by the rancher. The accounting was maintained by the rancher. The cowboy had no way to verify either. In practice, many cowboys found their monthly expenses consistently exceeded their wages. They worked. They owed more than they earned. They could not leave because leaving while in debt to an employer was, in some frontier jurisdictions, treated as a form of theft. They were not enslaved in the legal sense, but the practical difference between their situation and slavery was sometimes difficult to identify from the inside. Ranchers who ran this system faced no legal consequences for it. There were no labor laws prohibiting it, no wage theft statutes, no regulatory body to complain to. You worked, you owed, you stayed. Number 7, no pay for the injured. A cowboy injured on the job had no legal right to any compensation whatsoever. No medical coverage, no sick pay, no disability provision. The trail boss might choose to pay for a doctor out of personal generosity. More commonly, the cowboy was left at the nearest town with whatever remained of his last pay, and the drive moved on. If his injuries prevented him from working, he could not sue, could not claim, could not do anything. And when he recovered, if he recovered, he went to the back of the hiring line. Because injured cowboys had reputations for being damaged goods. The law did not see this as a problem. Workers had no rights that employers were bound to respect. That was simply the arrangement. Number 6, riding the unbroken horse. Every ranch needed horses broken for riding, and in the frontier era, the method of breaking a horse was to put a man on it and keep him there until the horse stopped fighting. This was not voluntary work for the cowboys assigned to it. A man who refused to ride an unbroken horse faced dismissal. A man who was thrown and injured was expected to get back on. A man who showed sustained reluctance was considered unfit for the work and replaced. Bronco busting caused a specific pattern of injury: dislocated shoulders, fractured wrists from breaking falls, spinal compression from repeated hard landings, concussions from being thrown headfirst into the ground. These injuries accumulated over a career. Cowboys in their 30s often moved with the careful stiffness of men 20 years older. The rancher faced no liability for any of it. You signed on knowing what the work was. The work was what it was. Number 5, the forced confession. In frontier communities where formal legal structures were weak and mob patience was thin, an accused man sometimes faced a simple choice: confess publicly or face what came next. The public confession, standing in the town square or outside the saloon and admitting guilt before the assembled community, was coercive by design. It was presented as leniency. Confess, and the mob was satisfied. Refuse to confess, and the mob's options expanded significantly. The confession was then used as the basis for whatever punishment followed, legal or otherwise. Men confessed to things they had not done because the alternative was a rope or a beating or both, and a public confession was survivable. The frontier justice system recorded this as the accused taking responsibility for his actions. Number 4, disarmament and immediate arrest at city limits. In the major cattle towns, Dodge City, Tombstone, Abilene, Deadwood, ordinances required cowboys to surrender their firearms upon entering the city limits. This sounds reasonable. The enforcement was not. Cowboys who did not immediately comply with disarmament orders could be arrested on the spot. The arrest did not require a trial. The marshal could hold a man for a set period, fine him, and release him, or simply beat him and tell him to get out of town. Documented accounts from Dodge City describe marshals using physical force to enforce disarmament. A man who was slow to hand over his weapon, or who argued, or who simply looked like the wrong kind of trouble, found himself on the wrong end of a badge with very broad authority and very little oversight. The ordinance was the law. The enforcement was whatever the marshal decided it was. Number 3. Wrongful execution with no recourse. Tom Ketchum was hanged in Clayton, New Mexico in 1901. The drop was miscalculated. The rope decapitated him. His head separated from his body in front of a crowd that had gathered to watch a legal execution. This was not the only bungled frontier execution. Documented cases of men strangling slowly over several minutes, the drop too short to break the neck, the rope slowly tightening as the condemned man's weight did the work, appear throughout frontier hanging records. The family of an executed man had no legal recourse. The state had carried out its sentence. That the sentence was carried out incompetently was not, in the view of frontier courts, a violation of anything. But beyond the mechanical failures, men were hanged on the frontier for crimes they did not commit. Eyewitness accounts were unreliable. Confessions were coerced. Evidence was thin or fabricated, and once the trapdoor dropped, there was no appeals court that could undo it. The law had spoken. The law was finished with the matter. Number 2. Collective punishment for individual crimes. In frontier communities, the punishment for one man's actions was sometimes applied to the group he belonged to. A cowboy from a specific ranch was convicted of theft. The entire crew from that ranch was refused service at local businesses, denied access to the saloon, turned away at the hotel. A single cowboy's altercation with a local citizen could result in his entire outfit being banned from a town for the duration of their stay, hundreds of miles into a drive, with no alternative stop for supplies. The legal basis for this collective exclusion was simple. None was needed. Private businesses could refuse service for any reason. Town ordinances could exclude groups at the discretion of local officials. The men who were punished for what their colleague had done had no legal remedy. They were associated with him. On the frontier, association was sufficient. Number 1. Execution for horse theft. Here is the one that gets misquoted the most. Horse theft in the Old West was not always a capital offense in law, but in practice, it frequently was. Not because the law mandated death, because the frontier community executed horse thieves regardless of what the law said. And here is why that made a brutal kind of sense. On the frontier, a man's horse was not a luxury. It was his transportation, his livelihood, his means of obtaining water, his tool for every task that kept him alive. A cowboy without a horse in the middle of open range was a man in serious danger of dying, slowly, of thirst or exposure, or simply being unable to reach help. Taking that horse was not just theft. In the frontier understanding of the act, it was potentially murder by another means. So communities hanged horse thieves, without waiting for a circuit judge, without conducting a formal trial. The vigilante committee decided, and the rope was available. The law did not always endorse this, but the law was often not present. And when the law arrived afterward, prosecution of the lynching party was rare enough to be exceptional. On the frontier, the law was what the community decided to enforce. And the community had decided that stealing a horse was worth a man's life. That calculus was brutal. It was also, within the logic of the frontier, completely rational, and nobody went to prison for making it. The cowboy of the Old West is remembered as a symbol of freedom, and he was free in a certain sense. Free to work 18-hour days for $30 a month. Free to ride drag through 3,000 cattle in August. Free to be blacklisted, flogged, branded, banished, or hanged by whatever combination of legal authority and mob justice happened to be operating in his county. The freedom of the frontier was real. It just wasn't evenly distributed. The laws that protected workers, that guaranteed wages, that gave a man the right to challenge his punishment, those came later, built in response to what the frontier had demonstrated about what happens when nothing stops the people in power. The cowboy paid for that education with his back, his years, and sometimes his life. Most of them never got credit for a single day of it.